right, I'll begin the program then. We want to welcome you all to the fourth annual now, 2024 Seigenthaler Debate here at the Catholic University of America's Columbus School of Law. I'm A.G. Harmon, the Associate Dean of Bench and Bar Programs. We welcome you all here to this debate and thank you for joining us. The purpose of the First Amendment initiatives, of which this program is a part, is to provide a collegial forum that fosters debate, dialogue, and study of First Amendment issues from all sides. Catholic Law is proud to be a leader in this area of legal education and hosts this program, along with the Seigenthaler Sutherland Cup First Amendment Moot Court Competition, now in its 75th year, and the oldest moot court competition of its kind in the nation. The Judicial Clerkship Opinion Writing Conference, concluded just last week, and the Center for Religious Liberty. This debate is co-sponsored by our school's chapters of the Federalist Society and the American Constitution Society. We thank them both. The Seigenthaler Debate features two First Amendment scholars engaging a free speech issue that is to be mooted during the upcoming Seigenthaler Sutherland Cup competition. The debates are named after John L. Seigenthaler, journalist, publisher, and free speech advocate. The resolution that is the subject of this year's debate is resolved. Restrictions on public funding of scientific research that are based on consensus/orthodox definitions of science are unconstitutional conditions. Each position, pro and con, will begin with an opening statement on the topic, followed by questions from our moderator. Participating in our debate and taking the pro position is Jenna Yanis, litigation counsel with the New Civil Liberties Alliance. Taking the con position is Robert Charo, former general counsel with the Department of Health and Human Services. And our distinguished moderator for this evening is the Honorable Justin Walker of the United States Court of Appeals for the District of Columbia. To introduce our debaters and our moderator more fully, I'll now turn the floor over to Professor Robert Destro of Catholic Law. Professor Destro is the former Assistant Secretary of State for Democracy, Human Rights, and Labor at the Department of State, a past commissioner on the United States Commission on Civil Rights, and a former general counsel to the Catholic League for Religious and Civil Rights. Professor Destro.
Thank you, Professor Harmon, and welcome to all of you. It's my honor and pleasure tonight to introduce our debaters and our distinguished moderator. So let me begin by introducing our debater is going to be Ms. Jenna Yanis of the New Civil Liberties Alliance. She has litigated against COVID-19 vaccine mandates. She's played a significant role in First Amendment challenges to the government's involvement in censorship on social media, including in Missouri versus Biden, a case originally brought by the Attorneys General of Missouri and Louisiana, in which the New Civil Liberties Alliance represents two of the co-signers of the Great Barrington Declaration, Drs. Jay Bhattacharya and Martin Kulldorff. She led the New Civil Liberties Alliance's successful efforts to obtain a preliminary injunction against California's law punishing doctors for disseminating so-called misinformation about COVID-19 to patients. Ms. Yanis also served as senior special counsel on the House Judiciary Committee's Weaponization of Government Subcommittee's investigation into the government's role in censoring speech on social media. Arguing the con position tonight is Robert Charo. Mr. Charo is the former general counsel of HHS. He is currently a shareholder at the law firm of Greenberg Traurig. He was nominated by President Donald Trump to be the general counsel of the United States Department of Health and Human Services and was confirmed on December 21st, 2017. He previously worked for the law firm of Crowell and Mooring. In the Ronald Reagan administration, he served as deputy and then principal deputy general counsel for the U.S. Department of Health and Human Services. In those roles, he supervised the chief counsel for the Healthcare Financing Administration, the Office of the Inspector General, the Food and Drug Administration, and the United States Public Health Service. And our distinguished moderator tonight is the Honorable Judge Justin Walker of the U.S. Court of Appeals for the District of Columbia Circuit. Judge Walker was appointed to the Court of Appeals in September 2020. He is a graduate of Duke University and Harvard Law School. He clerked for then Judge Brett Kavanaugh and Justice Anthony Kennedy. In 2019, he was appointed to the U.S. District Court for the Western District of Kentucky. Prior to that, he practiced at Gibson, Dunn and Crutcher's D.C. office and in Dinsmore and Scholl in Louisville. He's taught law in several states and in foreign countries. So welcome to all of you. Welcome to our audience. And I'm going to turn the program now over to Ms. Yanis, and she's going to argue the proposition. Thank you.
Yanis, I think you're muted.
You're muted.
Sorry about that. Thank you very much. That's the danger of the mute button, I guess. So just to start, I want to clarify that I'm defending the position that public funding of science can't be restricted because the theories involved are unorthodox or in the minority. I'm not defending things that aren't science because they don't implement the scientific method like astrology. So I'm not saying that anybody can call something science and they should get public funding. Rather, I'm disputing the claim that researchers can be denied funding because they reject the consensus or orthodox view on scientific questions. First, such a policy is unlawful because it constitutes an unconstitutional condition. A policy that denies funding to those who don't hold the consensus or orthodox view constitutes viewpoint discrimination, which the Supreme Court has resoundingly said violates the First Amendment and are presumptively unconstitutional. Here, predicating a benefit, that is receiving funding for scientific research, on adhering to a certain viewpoint is an unconstitutional condition. The Supreme Court has also held that the government can't deny a benefit to a person on a basis that infringes his constitutionally protected interests, especially freedom of speech. In Spicer v. Randell, the Supreme Court, made the point that this would allow government to produce a result it couldn't command directly, indirectly. In other cases, the Supreme Court has said that the unconstitutional conditions doctrine forbids burdening the Constitution's enumerated rights by coercively withholding benefits from those who exercise them. The Supreme Court has also specifically held that the government cannot compel a grant recipient to adopt a particular belief as a condition of funding. In the Agency for International Development versus Alliance for Opening Society, the court said, this case is not about the government's ability to enlist the assistance of those with whom it already agrees. It is about compelling a grant recipient to adopt a particular belief as a condition of funding. And by demanding that funding recipients adopt as their own the government's view on an issue of public concern, the condition by its very nature affects protected conduct outside the scope of the federally funded program. Similarly, in a case called Legal Services Council versus Velasquez, the court held that Congress couldn't deny funding to legal services attorneys and clients because the attorney's representation involved efforts to amend or challenge the validity of existing welfare laws. The court said where private speech is involved, even Congress's antecedent funding decisions cannot be aimed at the suppression of ideas thought inimical to the government's own interests. Second, so first, it's unlawful unconstitutional conditions under unconstitutional conditions doctrine. Second, predicating the funding of science on researchers adhering to a consensus view is bad policy. First, the term consensus is vague and it can't be defined. Whose consensus? Is it all scientists, all science in a particular field? Which field? How do we know what the consensus is? Do we take polls? So this is a very vague term that makes it difficult to even implement the policy. But maybe even more important, predicating funding on adhering to consensus definitions of science hamstrings scientific inquiry. It's self-perpetuating. If we can't test alternative theories that go against the consensus, we can't actually find out if the consensus view is wrong or if it could be improved upon. So it's almost the opposite of science, or it encourages the opposite of science. It sort of solidifies orthodoxy. As we saw during COVID, the consensus at a given moment is often wrong. One day masks don't work, the other day they do, the next day they don't. One day the COVID vaccine stops transmission, the next day it doesn't. So even when it appears that there is a consensus, the consensus can be wrong. We also don't know what the consensus is when people are punished for voicing viewpoints that differ from orthodoxy. So it might appear there's a consensus when there actually isn't. So the Great Barrington scientists who I represent were censored on social media. So perhaps it appeared that there was a consensus that lockdowns were a good idea, but they didn't think so. But the public got that impression because scientists who dissented were censored, including by the government. There are other means of ensuring that the research being funded is legitimate science without engaging in unlawful viewpoint discrimination or restricting science in ways that ultimately will be harmful. For example, those who are in charge of approving grants can ensure that researchers are using the scientific method. That's a much better standard than adhering to a consensus. So, on that note, I will turn it over.
Mr. Chara, would you like to take over?
I would. Thank you very much, Professor. I'm going to be examining a couple of hypotheticals with the understanding that I'm going to be examining primarily the definition of what we mean by science and whether an orthodox definition of the concept of science, in fact, holds sway when awarding grant applications. Let's start with a couple of simple hypotheticals. Suppose that you've just been confirmed as the secretary of a brand new cabinet department, which combines a bunch of science agencies such as NASA, NOAA, and NIST. Because the new cabinet department is still trying to get its act together, it's affectionately known as the Department of Chaos and Confusion. Your department is supposed to award scientific grants that study the impact of heavenly bodies on the earth or its inhabitants. Since the department started operations near the end of a fiscal year, it can only make a single grant. You have two applicants competing for that grant. The first applicant proposes to study whether the existing mathematical models, recognized as correct by virtually all astronomers, accurately predict the impact of Jupiter's orbit on the Earth's orbit, which can affect average temperature on the Earth. The second applicant also proposes to study the impact of Jupiter's orbit, but instead of measuring its impact on the Earth's orbit, it seeks to assess a principle of astrology, namely whether those born when Jupiter, Saturn, and Earth are aligned have more pleasing personalities than those born at other times. This is a zero-sum game, so if one applicant gets funded, the other doesn't. You decide to reject the second application because it's not science in your view and doesn't follow the scientific method because there's no underlying theory induced from observation. However, your general counsel, known as the Honorable Mr. No, tells you that if you decline to fund the astrologer because he's following a definition of science well outside the mainstream, then you could be sued under the First Amendment because you've declined to fund him solely because he is not practicing science as that term is normally defined by the scientific community. But if that's the case and you follow your GC's advice by funding the astrologer, then you're automatically declining to fund the real scientist because he's proposing to practice science as normally defined, and he too can sue you. In short, using the First Amendment to take the science out of science will lead to potentially absurd results where no one can ever get funded without risk of First Amendment litigation. Now let's try another hypothetical that assumes that everyone is following the orthodox definition of science. Suppose that the National Institutes of Health receives two grant applications, both using the consensus definition of science. NIH grades grant applications numerically. The lower the score, the better the application in the view of the reviewers. Let's assume that one application gets a lower score than the other, and NIH decides to fund that as opposed to the other. It tells the loser that the reason it has not funded her application is because the experiments that she proposes doing do not fit within NIH's incremental chain of discoveries. In other words, most science agencies, I shouldn't say most, NIH in particular, which is the largest single funder of research in the country, they have programs in place to make incremental discoveries. So they look for stepwise experiments. And if you don't fall within that stepwise pattern, you invariably receive a higher score, which is actually a lower score, and you don't get funded. This allows NIH to discriminate precisely on the basis of what you've said in your grant application. But obviously, if NIH could not discriminate on the basis of what you said, it would have no way of discriminating between grant applications and could never award a competitive grant application. Now, bear in mind, the government has been competitively funding scientific research off and on since the 1830s under the Necessary and Proper Clause. Now, these hypotheticals illustrate that from a constitutional perspective, the resolution we're debating is far more about appropriations and the appropriations clause than it is about the First Amendment. Congress appropriates funds for specific purposes, and that's just the nature of the beast. So, for instance, when Congress appropriates funds to a state to build a bridge between 2 points, it expects the funding applications will propose building a bridge between those 2 points and not an amusement park or a football stadium. Correspondingly, when Congress appropriates funds for science research, it expects those funds to be used for science. And it also expects to award the grant applications in question to the applications that it views as the best and the ones that are likely to foster whatever scientific goals it may have in mind. There's actually a statute that makes it a crime to spend federal funds for a purpose not authorized in the appropriations, and it's called the Anti-Deficiency Act. Now, the term science is actually used in the Constitution and was understood by our educated founding fathers to carry the meaning developed by Francis Bacon in the 17th century. Bacon required, among other things, that one first conducts observations, and from those observations, using inductive reasoning, formulates a general principle that explains the observations. And from the general principle, one can make predictions and actually test those predictions. And Sir Isaac Newton did just that when he was developing or inducing his 3 laws of motion. Now, conditions requiring one to do science, as understood in the scientific community when receiving money for scientific research, directly relates to how the recipient will actually spend the money. Conditions that directly relate to public funding have consistently been upheld by the courts, including our Supreme Court. These conditions must be distinguished from conditions that do not directly relate to how the public money will be spent, such as the USAID case that was cited to you earlier. The court has consistently held the government has no obligation to subsidize even the exercise of fundamental rights. And let's take a look at Rust versus Sullivan, a case from 1991. At issue in Rust was whether Congress and HHS, as part of a family planning grant, can preclude a grantee, such as Planned Parenthood, from using federal funds to counsel about abortion. Title 10, which created the family planning program, stated that, and I quote, "None of the funds appropriated under this title shall be used in programs where abortion is a method of family planning." The implementing regulations sought to do just that, to implement that provision, and the court concluded that, quote, "There is no question but that the statutory prohibition contained in Title 10 is constitutional." Rust went on to articulate that there's a distinction that has emerged from court cases between conditions that define the limits of the government spending programs, those that specify the activities Congress wants to subsidize, and conditions that seek to leverage funding to regulate speech outside the contours of the federal program. Now, that is obviously a mushy line, but nonetheless a line. Conditions that fall into the first category, such as those in Rust, have consistently been upheld against First Amendment challenges, and conditions that fall into the second category are more amenable to challenge. Now, the Agency for International Development, which was cited to you a few moments ago, illustrates the vulnerability of leverage conditions. At issue there was a grant program aimed at helping combat the spread of HIV/AIDS around the world. The act imposed 2 conditions on the funding. First, no funds made available by the act could be used to promote or advocate the legalization or practice of prostitution or sex trafficking. And the second one, no funds made available may be used by an organization that does not have a policy explicitly opposing prostitution and sex trafficking. Before the court was the second condition, and the court held that there is a distinction between conditions that define limits of the spending program, and specify the activities of Congress wants to subsidize, and conditions that seek to leverage funding to regulate speech outside the contours of the federal program itself. The second restriction fell into the second category. Putting science aside for a moment, if one could not discriminate on the basis of speech when awarding a grant application or even a procurement contract, then we would be unable to award funding in any form, whether it be by grant or procurement contract. And I now turn the meeting back over to, is it Professor
To Bob
Destro?
Destro. And before I turn it over to Bob, I just wanted to say something to the audience. If you have a question, please post it in the chat feature of the webinar, and we will reserve time after Judge Walker's questions with the debaters for questions from the chat. So if you have a question, please post it in the chat feature of the webinar. All right, I turn things over to Bob Destro again.
Well, thank you, AG. Thank you, Mr. Charo. And now I'm going to turn the floor over to Judge Walker, and we can get into the questions and answers. Thank you.
Thank you, Professor Destro, and thank you, Professor Harmon. It's a real treat to be here and to be a part of this debate tradition at Catholic. I thought maybe I would just start by giving Ms. Yanis a chance to respond to anything that Professor Charo said that you wanted to respond to. And then I'll give him one last chance to respond to you, and then I'll ask some questions.
Thank you so much. We may agree on more than we actually disagree on.
I was worried about that.
Yeah.
We both started with the astrology example, I noticed. So I certainly agree that if you have a program that's designed to fund science, government has no obligation, and it's perfectly acceptable to discriminate against applications that aren't about science. And I agree also that the line is murky. At what point does it become viewpoint discrimination, and at what point is it a legitimate evaluation of the recipient's intended research? Obviously, we can't have everybody awarded grants. Some judgments need to be made. So I'm merely defending the position that the government can't require the recipient to follow the so-called consensus. I'm not arguing at all that the government can't think that one idea is better than another. And I do want to point out that Rust is a little bit different than this proposition, because the government was simply insisting that the funds be spent for the purposes on which they were authorized, for family planning, not abortion. So here, the idea is to fund science, this doesn't actually, the funds wouldn't be used for something that's not science, again, and I wouldn't defend the proposition that they could be. And that's the whole notion of the unconstitutional conditions doctrine applied in this context, that the government can't say that one viewpoint is preferable because it's part of a consensus, or because it's the consensus. So those are essentially my areas of disagreement.
Great. And Mr. Charo, I said I'd give you a chance to respond as well.
Yeah, I think the scientific community, as a general rule, does discriminate on the basis of viewpoint in terms of awarding funding and in terms of accepting publications. And that is a tried and true predilection. Whether it's good or bad is something else again. But there is a wonderful podcast by Malcolm Gladwell called The Obscure Virus Club, which looks at 4 scientists who in the 1950s and 60s claimed that RNA viruses could cause cancer. And of course, the general orthodoxy was it went DNA, RNA, never RNA, DNA. And so their papers were never published and they were ostracized. And then lo and behold, two of them independently discovered that there was this little chemical that transformed the RNA and the virus to DNA. The DNA got into your nucleus and genome and did bad things. It was that enabled people to, in fact, know what the AIDS virus was, because it was one of these RNA viruses that worked just that way. So it took these people a long, long time. One of them has a big letter from one of the major journals framed in his office. It says, the letter actually says, never submit an article like this again to this journal. And two of the four won Nobel Prizes, by the way, for their work. So science works slowly, and there are, beliefs, and those beliefs ought not to be subject to litigation. It's just the nature of the beast.
I wonder if that story though doesn't help Ms. Yannis's position. So it seems like the researchers had a view that was outside the mainstream, and in hindsight, we would have been better off giving them more funding. So why doesn't that help her position?
It actually, because in the long run they did get funding, and in the long run they made the discoveries, and in the long run it worked out without judicial intervention.
Well, but in that case, what's the point of ever having funding if it's just going to work out in the long run anyway?
Well, what I'm saying is, the last thing you want to have is a court entertaining which two grant applications are better. You wouldn't want to do that, would you? As a district judge?
I have no opinions. I have no opinions here.
Yeah, I'm saying as a district judge, for example, that's why there are relatively few cases dealing with unsuccessful putative grantees.
Yeah, but I get that we don't want judges deciding what
Right.
to fund, but I think there would be some people who say we don't want members of Congress deciding that either, and so why not fund consensus scientific research and unorthodox scientific research.
Agencies, as a general rule, tend to fund things, if you're looking at scientific proposals as a bell-shaped curve, they tend to fund stuff near the middle of the curve and not on the tails, because the probability of success is greater, and therefore, as the probability of success goes up, the likelihood of getting more appropriations in subsequent years increases.
Let me turn to Ms. Yannis. What is an example of something that you think should be funded? It fits in the box that you're calling science, but it's unorthodox, and you understand the types of restriction in the debate resolution to prohibit funding of it, and you think it should be funded. Can you give us an example?
Sure. So I think a big one is the idea that masks are effective at reducing the spread of viruses. So that kind of took off as a proposition during COVID, even though it hadn't really been considered to be an effective means of stopping respiratory viruses before. And there was a political aspect to the belief. I think most people noticed that, it was Democrats who were promoting the mask idea and a lot of conservatives who were against it. And so I think that science got lost in the shuffle. And, I looked at some of the CDC studies supposedly saying that masks work. They were highly problematic, in my opinion. One of the ways or bases for the idea that masks were an effective means of stopping the coronavirus was a salon I think in Missouri, where a hairdresser had COVID and wore a mask and none of his clients got infected. I wouldn't call that science. So I think now it's considered so much to be the consensus view that it's not even debatable anymore. But I don't think that the evidence for it is very solid. And yet my doctor still makes me wear a mask. You can argue it's not that big of a deal, but I think it's important that if we implement public health measures in society, that there should be scientific research to back it up for all sorts of reasons. I mean, people simply shouldn't be forced to do something, even if it's as small as wearing a mask, if there's no evidence to support it. It reduces people's trust in science when they feel like a measure is being imposed on them that isn't backed by solid evidence. So that's one example. And I think you'd have a hard time getting public funding for that research now because of the sort of religious mentality that masks have taken on.
So I have I guess a technical question to follow up with, and then a clarification question, and then I'm curious what Mr. Charo would say to that research proposal if he thinks that Congress could pass a law restricting public funding for that kind of scientific research. But my first kind of technical question is: you said you think there's not the evidence to suggest that masks prevent the spread of respiratory viruses. Do you think? I mean, doctors were wearing masks in surgeries, and for decades before COVID came along. So, what do you think they stopped the spread of something, or do you just think they never worked to stop anything?
They never worked. So my understanding is, with the caveat, I'm not a doctor or a scientist, they were typically used in order to stop droplets from, you're operating on somebody, you don't want saliva falling in the incision or whatever. They were not used to sort of just, you couldn't just put them on and stop the spread of viruses. And the idea of asymptomatic people in particular wearing masks has no basis in science. And there have been a couple of randomized control studies, one that was done during COVID in Bangladesh and another from Denmark. And both really showed no effect for like masking of the population.
So my clarification question is, you're imagining that there would be a scientific researcher who comes along and seeks NIH funding or some kind of funding for a project that hopes to demonstrate that masks don't stop the spread of COVID, let's say. Is that kind of the research you're imagining that
Sure, yeah.
Okay. So then I guess my question to Mr. Charo is, let's take that hypothetical. Maybe we finally found something you both disagree about, but maybe we haven't. And let's say that Congress has just passed something even more kind of precise than the resolution in the debate today. Imagine Congress has passed a statute that says no scientific funding for anyone whose research attempts to deny the efficacy of masks in terms of preventing the spread of COVID. And then along comes a researcher who wants to do exactly that kind of research. Do you think that the First Amendment would allow Congress's restriction? And then putting aside the constitutionality of it, do you think it's good policy?
First of all, I think the First Amendment would not prevent Congress from doing that.
Okay. So, and why is that? Why do you say that?
Because I think Congress has relatively unfettered discretion when it comes to deciding how public funds will be used. And if it doesn't want public funds to be used for a particular set of scientific researchers, it can do that. It can write that into the statute. It's done that in the past many times.
What's the difference between that and Congress writing into the statute that Legal Services Corporation can't receive funds if they're going to make the kind of challenges to welfare regulations that were at issue in the Velasquez case, or the Trinity Lutheran state has a policy that prevents this church from getting funds for its playground.
Right. The famous Missouri Tar case, as I refer to it as. I think Trinity Lutheran is very different because Trinity Lutheran is dealing with a set of beliefs that are outside of the playground. And this is not dealing with a set of beliefs outside of the funding. It is directly related to the funding. That's the distinction, I think, that all three of us recognize exists. There are.
Yeah, I mean, I think you can. I mean, I think you can frame it that way, but you could frame it that the funding is for secular playgrounds, not for religious playgrounds. I think that's what Missouri would have said. So it does go to, it's not for church playgrounds.
But it
That's-
doesn't. But it
That's
doesn't
outside
relate,
the scope of the funding.
right. It doesn't relate to the playground itself. It relates to the beliefs or the nature of the applicant. And that's not.
I mean, and don't get me wrong, I like Trinity Lutheran. So, what about do you think Velasquez was just wrongly decided, or do you think you can distinguish Ms. Giannis's hypothetical from legal services versus Velasquez?
Yeah. It may have been wrongly decided.
Okay.
I think the current trend would have been probably to find that if the challenges were being actually supported with federal dollars, then it would be properly decided. If the challenges were being supported by private dollars, on the other hand, then obviously the imposition of that condition would be unconstitutional.
I have one.
It all depends on what the dollars are being used for.
Okay. And I was going to ask about another case, but why don't we turn to the policy question, and then I'll give I have some more questions for Ms. Giannis. Do you now imagine that you're just a member of Congress and you want what's best for the country? It's constitutional to pass a restriction that bans research into the research that hopes to prove that masks do not stop the spread of COVID. It's constitutional to do that, you say, but is a good policy. Would you vote for it as a member of Congress?
Well, there's actually a fascinating set of studies that were done by the deputy director of NIH for extramural programs, the person who's in charge of the $35 billion. And what he did was he wanted to see if there was any difference in the quality of the research done based on the scores that were received by the applicants. Remember, the lower the scores, the better the application. He wanted to see if a lower score corresponded with being cited more frequently in future years. And he found absolutely no relationship. So he found that the peer review system at NIH did not discriminate well enough, which tends to lead one to believe that attempting to ordain where science is going to go, whether it's done congressionally or through an agency, is not necessarily great policy.
There's more agreement between you and Ms. Giannis.
It's bad policy, yes, but is it constitutional? Yes. That's the beauty of the Constitution. It gives the executive branch the opportunity to make dreadful mistakes.
Well, let me turn back to Ms. Giannis. You drew a distinction between science and not science, and you said something along the lines of science is something that uses the scientific method. I wonder if that itself isn't suppressing dissent. Why is it okay to say yes funding for scientific method, no funding for not scientific method, but not okay to say yes funding for masks are good, but no funding for masks are bad?
So assuming my definition of science is correct, I'm not a scientist, but assuming
can you remind us what is the definition?
Following the scientific method, I
Okay.
think Mr. Chero described it or defined it pretty well, but I accept that definition. Since the policy or law is about funding science, if it's not science, then it doesn't, obviously that's not what the aim of the law or policy is. So it's entirely acceptable, in my opinion, to say, okay, if it doesn't fit the definition, then we're not going to fund it, using this program. The mask hypothetical is different because it's almost the opposite of science to refuse to fund people who say, you know what, I think, sorry, scientists, not just people. I think masks don't work for whatever reason. I've come up with a well-designed study to test. We've never had such a well-designed randomized controlled study. You know, I've maybe made some observations in the line of my work that they haven't worked so well. I've designed this study. And if the funding is denied simply because the scientist thinks the outcome of the study might be that masks don't work to stop the spread of respiratory viruses, then you're actually engaging in the opposite of science. So arguably, at least, it's sort of the opposite. Like the funds are being appropriated to cement an orthodoxy rather than to engage in the scientific process.
Well, what if we took the word science out of the restriction? Because I take your point that if we're going to fund science, then you have your argument kind of goes from there. But what if Congress says we are going to fund, whether it's science or not, we're going to fund research that tries to show that masks prevent the spread of COVID. We're not going to fund research that doesn't show masks prevent the spread of COVID. Now is that suddenly constitutional now?
That's a good question. I mean, it doesn't seem like a very good program to me because yours.
No, I mean, I think actually Mr. Charo would agree with you about it being bad policy. I think based on his answer to my last question, but just in terms of whether it's constitutional or not, does that change the constitutional analysis? It doesn't really change the substance of what's going on, so it seems odd that it would change the constitutional analysis. But so much of your argument seemed to depend on the word science kind of being in the funding restriction.
Yeah, and I mean, I guess the part of the notion is that if the pursuit is science, then you have to be funding science. So if what you're funding is just orthodoxy, we just want to put out more studies that show that masks work, then you're not funding science. So in a sort of ironic twist, perhaps your hypothetical, it would be hard to make a constitutional argument. I agree with Mr. Charo that the courts are not the best venue for this. One would hope that Congress is wiser and that we just wouldn't have policies that would only permit funding when the scientists follow a consensus. But obviously, I understand that's not the issue being debated.
Well, so he mentions, maybe along those lines of when courts, the role of courts and when they should get out of the way or when they should step in. He mentioned Rust v. Sullivan, and there the court said that the government restriction on the use of public funds was okay, and there the restriction was if you're going to receive these funds and you're going to do family, as you said earlier, if you're going to do these funds, you're going to use them for family to counsel on family planning. You cannot use them to counsel on abortion. You said, in your view, abortion is not a form of family planning. Do you think that the case was rightly decided?
I don't think it's necessarily consistent with some of the court's other jurisprudence. I think they've tried to split hairs in some ways that aren't totally logical. So.
Fair enough. I think that answer is probably quite consistent with with your position in the debate. I'm not entirely sure. But anyway, I'll leave you to that. It seems like Mr. Charo wanted to jump in.
Yeah,
so I don't want to stop you.
Of course, I thought Rust was properly decided because of my case.
Well. So more kind of radical agreement in this debate. The next year, Catholic needs to find people who disagree with each other.
The mask question you asked was very interesting for another reason. When you do an experiment, you don't know how it's going to come out. So if Congress said you can only fund research that proves that masks work, the researcher goes out, does the experiment, and lo and behold, gets the opposite result.
Right. I mean,
Right? So it works out.
I mean, I think that, so maybe say that again.
Okay. Let's make believe Congress, as you in your hypothetical, passes a law, says you can only fund research that shows that masks work. Researcher goes out, does an experiment hoping to find that masks work, and lo and behold, they don't work. In other words, Congress cannot ordain the results of the experiment.
Yeah, but don't you think the results of an experiment are going to be somewhat influenced by the agenda of the experimenter? I mean, maybe if scientists were perfect, and they came with no biases, but I mean, it seems like, for example, the scientists who try to show man-made effects on climate tend to do more studies that show man-made effects on climate, and the scientists, and I know that the climate change community might not even want to call them scientists, but the scientists who have done research showing that the climate crisis is not as big a crisis as some people think, they end up doing more studies that show support what they came up before. So I mean, isn't that dynamic? Isn't that at play if only because scientists are human and fallible?
It's the political influence that comes to bear. Sometimes the ego influence. I mean, one can design experiments so they will produce the results you want. Okay, that's possible, especially in things like epidemiology.
I mean, that was my question.
Yeah.
Just,
but in theory, if you have a real scientist, they will not design an experiment that way.
Let me give a hypothetical to Ms. Yanis. I think in some of the early days in the war on terror and in the war in Iraq, there was a funding program for anti-mine equipment, mine-resistant materials. And imagine there are two applicants for this $1 million grant, and they both need $1 million, so they can't both get the million. And one is gonna, propose, to study mine-resistant technology that everyone would consider sort of in the mainstream of technology that is likely to be mine-resistant. And the other has a theory. They're going to use a scientific method. It's going to cost $1 million to do their experiment. And they think that painting Humvees purple will make them mine resistant. And the grant administrator gives the money to the not to the purple paint researcher. Do you think there's a First Amendment violation there?
No, because the purple one is
Why not?
I mean, I would say that that's not science. I mean, sure.
I mean, they're going to do a scientific method. They're going to have a control group. They're going to have a variable. They're going to, they're going to play by all the rules. And I mean, I think you're saying that restrictions on public funding of scientific research that are based on consensus orthodox definitions of science are unconstitutional. So why is that restriction constitutional?
So, I mean, I sort of spent the last 24 hours trying to figure out how we draw these lines, and it's not easy, but one would assume that somebody with an advanced, degree or a degree in the sciences who's applying for these grants would not be proposing such an experiment. And there have to be gatekeepers, so the people on the committee or whoever approves the grants would have basic scientific knowledge and be able to assess the fact, like, before this goes through the gate, that this just isn't, this proposition is sort of observational reality defies the idea.
I mean, I think your answer is, you know, an answer that I think everyone would want that to be the answer. But I think there are, and I'm not taking a position. Yeah, it's not my role here, but I think there are people who would hear your view on masks and equate it with the purple paint theory. So, you know, what's the difference?
Well, I mean, that's the problem with things becoming orthodoxy when there isn't much science to back it up. So it's true. I mean, how do I prove that there's more reason to believe my claim is true than the purple one? I mean, first of all, we didn't use masks prior to 2020 to stop the spread of respiratory viruses. There were studies from before that showing they weren't terribly effective. There was a politicization of the whole issue, which I think casts doubt on the validity of the science. Another example from my personal experiences, I litigated a couple of vaccine mandate cases where my clients were being forced, or their employment was being conditioned on them receiving a COVID vaccine, even though they had natural immunity. They had recently had COVID, their employment at Michigan State University and George Mason University. And
was your client Todd Zwicky?
One of them, yeah. Yeah. We ended up in court with battles of the experts, with our experts coming in and saying natural immunity is better, and then the other side saying vaccine immunity is better. And I agree with Mr. Chero. I mean, to have courts deciding this question and sitting there looking at the questions of T cells and B cells and antibodies is a little bit ridiculous. And I think part of the problem lies with the fact that the science has been politicized. So the CDC put out study after study just in support of the notion that natural immunity wasn't good and the vaccine was much better. Aren't you inviting the court's intervention when you argue that something is unconstitutional? Yes, but it's sort of a last resort. You know, it's not where I think we should be as a society. I think we should be able to have public health agencies that are reliable and aren't politicized. Unfortunately, I think many of us learned during COVID that that's not where we are. So in the absence of other alternatives, challenging the CDC's guidance was sort of where I found myself, even though it's certainly not the ideal place to be.
Mr. Chair, if you want to respond, and then I thought I would ask you some kind of logistical questions about how scientific research grants work. Do you have any response? Feel free.
I think your answer was excellent.
Great. More agreement. I should be like a mediator, you know? It's like, you know. Okay, so this question comes from Bob Desro. Can you explain number one? And by the way, any participants who want to ask questions, feel free. Now is the time to type them into the chat. Professor Destro asks, can you explain number one, how grant applications are reviewed? Maybe we'll start there.
Okay. It all depends on the funding agency. They're reviewed differently because they're different statutory criteria. But let's look at NIH. And its statutory setup is great because it's unconstitutional on its face. But no one has standing to challenge it. Why is it unconstitutional on its face? Because the secretary is precluded from funding a grant application unless two advisory committees, the small advisory committee and the big advisory committee, agree that this is fundable. So it allows advisory committees consisting of folks who are neither officers nor inferior officers making the funding decision.
And I'm guessing they're not removable by the president at will.
No. Okay, so many rungs down.
So Ms. Giannis would probably agree with that too. That being unconstitutional as well.
So it's unconstitutional, but it's questionable whether anyone has standing to sue. The way the applications work is they're study sections consisting of usually scientists in 35 to 45 years of age who've had grant applications that have been approved and awarded funding. They sit in groups of 30 and in a hotel somewhere, and they review these grant applications and score them. And then the study section leader who's a NIH employee totes up the scores, averages them out, and then figures out where the pay line is based on how much money he has. And that goes up the chain to the next advisory committee. That is the NIH model. The NSF model is very different because it largely does not use federal bureaucrats. And so you do not have a consistent line of funding. So in NIH, certain types of research will be funded, other types will not. At NSF, that's not the case because the people who make the decisions are only there for 2 years. They're profs from universities who spend 2 years at NSF and then they leave. So you get a greater distribution of the types of science funded in NSF than you do at NIH.
That's great. That's very helpful. I had no idea, and I suspect our audience, the students in the audience who've already written briefs about this and who will be doing oral arguments on a related topic, may not have known either. At least some of them may not have known. Before I ask Professor Destro's other question for Mr. Chero, his answer made me think of a question for you, Ms. Yanis. Imagine this kind of unconstitutional regime, whatever it is that Congress can't do in terms of funding private scientific researchers. Maybe just take the mask example again. Congress can't pass a law saying we're gonna fund the pro-mask research, but we're not going to fund the anti-mask research. Imagine that instead of that environment for scientific research, the government just insources all the research. It doesn't ever grant funds to private researchers. Instead, it spends $35 billion every year hiring its own scientists, its own researchers, has its own labs. Everybody's a government employee. All the funding is government research. Could they, as a matter of deciding what kind of government research to do, make a choice to do pro-mask research and not anti-mask research?
Well, probably, yeah. I mean, and I think that's kind of what we have.
I think so. But then if that's the case, then it seems like, that sounds like a much worse system.
It is, and
right in terms of like discovering, cures for disease and things, than the current system, which takes advantage of the the genius of the private sector and the competitive market, and kind of taps into that. So it seems a little weird, at least from a policy perspective, to say, well, it's unconstitutional to do pro-mask funding but no anti-mask funding when we're doing this private sector model, but it's perfectly okay as long as we make the model worse. The worse the model gets, the more constitutional it gets. That seems weird.
Yeah, it does, but as you probably know, that's kind of how the law works.
I know.
You can come up with these very ironic results. There may be other legal theories under which one could challenge that. I'd have to think that through much more. I think it would be difficult to make a First Amendment argument. I think there's more of a political solution that would have to be wielded there.
Yeah, great. Mr. Professor Despro's second question says, we hear quite a bit about consensus views on climate change that posit that carbon dioxide is the primary driver. He writes, isn't it likely that a grant proposal that seeks to understand the role of the sun or of the Earth's magnetic fields would be downrated because it deviates from the consensus? And another way of thinking it is, can you explain whether awarding agencies are required by the First Amendment to ensure that the reviewers do not slip into implicit consensus requirements? Do not slip implicit consensus requirements into their reviews. So that's his question.
I don't think there's a First Amendment requirement. There's certainly a policy reason why you would want to ensure that that doesn't occur, but not a First Amendment requirement. In other words, the way the First Amendment has been applied to science awards gives the executive branch the opportunity to make a fool of itself. And it can do that. It tries not to, but sometimes it can't help itself. And climate change is extraordinarily complicated.
Well, let me ask your view on Locke v. Davey. So it seems to me that it fits the kind of model you were talking about, where it's not like Trinity Lutheran. It's not like we're denying funding because of something unrelated to the use of the funding. Locke v. Davey, we're denying you a scholarship to study theology because we don't want to fund the study of theology. And the court said that's okay. And so which I think helps your position in this debate. But I wonder if you think that case was correctly decided.
That I do. I think it was correctly decided because that directly relates to the funding, the use of the funds.
Yeah. Do you think the Supreme Court thinks it's correctly decided?
I'm not going to ordain. I'm not going to ordain.
That might be unfair. Ms. Giannis, do you want to take a shot at if you think it was wrongly decided? And I think the argument that it's wrongly decided fits kind of comfortably with your position on the your support for the resolution and the debate. But on the other hand, if you don't want to weigh in, that's okay too.
I'll pass on that one.
Sounds good. So Professor Destro has asked another question, this one from Ms. Giannis. You made the statement that the science has been politicized in the mask context. Because how, as a practical matter, does a litigator make that case?
Well, various ways. So I haven't brought a mask case, but if I were to, I would show sort of the fact that, on whatever it was, I don't remember the dates, but February 27th of 2020, Fauci said masks don't work to stop the spread of viruses, don't buy them. And then by April, if you didn't wear a mask, you were a terrible person, and only Trump supporters didn't wear masks and that kind of thing. So I would sort of point to that kind of evidence, news articles even, and show that it was in a way a social phenomenon rather than a scientific one that took over. I mean, it's difficult, and as a litigator, honestly, I prefer not to be litigating these kinds of issues. I'm not a scientist, but unfortunately, during the pandemic, there was no way around dealing with a lot of what I saw as significant infringements on people's liberties.
Something you said earlier makes me want to ask you and Mr. Chero this question. There was, as you pointed out, there was at least some kind of correlation between views on COVID and party registration, and I wonder why.
I have a very strong view on that. And I say that as a former lefty. So I was a public defender in New York in 2020, and I would have affiliated myself with the left. And I was extremely shocked at how quickly all the people around me sort of adopted these views, even though I didn't think there was a lot of evidence, whether it was lockdowns, masks, and then vaccine mandates. And personally, that this isn't a legal question, but I think that a lot of it had to do with just a real antipathy towards Trump on the left, which I also held at the time, where people Trump is so reviled on the left that if he said, hey, I don't want to wear a mask, or masks don't work, then, masks must work. And I don't think, that's how we should conduct scientific inquiry. Yet I think it sort of went that way, not to mention how we should impose rules or policies on people.
Mr. Chair, I'm curious if you have a view, but I might expand the question and tie it even more closely to the resolution in the debate. I mean, it does seem like COVID is something of a cautionary tale. I think each side of the political spectrum can at least thinks they can accuse the other side of politicizing the science. There were these, I don't want to, not speaking for myself, I'm kind of summarizing what Ms. Giannis said earlier. There was a message from the government that masks don't work in the early days, and then the message became that they worked. There was a message in the early days that it spreads by surfaces, and then later a message that it tends not to. There was originally a message that a lab leak was an impossible explanation, and then it became an explanation that gained more support. And again, I'm not taking a position on who was right on any of those things, but if we're going to allow Congress to put funding restrictions on scientific research based on politicians' views of what's the truth, truth with a capital T. That kind of approach to viewpoint discrimination, I think, has a checkered past, or arguably has a checkered past.
I think part of what we witnessed during 2020 was that people were making their best guesses based on very limited information. And you had to do that under the circumstances. Otherwise, you'd have a paralyzed government. The fact that they were scientists led people to believe that their best guesses were science. But it wasn't. It was just that, a best guess. Was there time in 2020 to do experiments on masks? Probably not. We didn't have enough masks in the beginning, so it helped that masks didn't work. When we got enough masks, then perhaps it was easier for masks to work. Okay? But a lot of what occurred in that year, other than the vaccine and some therapeutics, was decidedly not science. It was a combination of political science, sociology, and some medicine, all mixed up in a cauldron.
What do you think science is? Ms. Giannis defined it as, research. Scientific research is research that uses a scientific method. Do you have a different definition of scientific research?
That's the way the Supreme Court defined it in Daubert when it interpreted 702 of the Federal Rules of Evidence.
If Congress passed a law and said you can do scientific research into curing cancer, but you can't do scientific research into curing cancer with alternative medicine, is that science? Is that a restriction on scientific funding, or is that kind of? Do you put is that a restriction on scientific funding?
That's a restriction on scientific funding. I don't know what alternative medicine is. I assume we're talking about drugs that people would consider ordinarily not viable cancer therapeutics.
Yeah, you go to. I'm far from an expert, but I think there are like whole stores that they sell stuff on the counter that's not. It's not a pharmaceutical. It's natural. It's nobody made it. Kind of.
Okay. NIH does fund that, by the way. Interestingly enough, you have a small group that funds research into alternative medicines. But it's a restriction on funding. That group gets very little money, and compared to how much is spent intramurally at NIH, which is about $2 billion, and extramurally, which is over $35 billion.
I wonder if Ms. Giannis thinks that is okay. That on the one hand, NIH says this is science, but on the other hand, NIH says we don't like it enough to fund it as much as traditional medicine.
I think that's problematic. I think that might qualify as an unconstitutional condition. It sort of depends on how you define alternative medicine. But if somebody comes up with a well-designed study that sort of doesn't defy observational reality, I don't think it should be lawful to deny funding because it's all, quote unquote alternative.
Let me give you an example of something that I think would not pass constitutional muster. And it's a variation, I believe, on Ms. Giannis's hypos and the judges. Let's make believe that a scientist submits an application to study climate change. Everyone agrees it's an excellent application, should be funded. But this scientist has published articles where he doesn't believe that climate change is man-made. The research he's doing has nothing to do with that. But he's published those articles and he's denied funding for that reason. Bingo. That, I think, crosses the line.
Yeah, and that's the trend. I mean, you say that's the Trinity Lutheran line, so I'm sure Ms. Giannis would agree with that. And we're nearing the end of the time for the debate, but I do want to ask at least one follow-up question to Ms. Giannis's last answer, and then give Mr. Carroll a chance to respond as well. Imagine that there's only $1 million left, and they've spent the other 34.99 billion. I don't know if I have enough nines in there or not. And there's $1 million left, and there's two proposals, and one is going to try to develop a medicine that will save lives. They both try and develop medicines that will save lives. But one of them is using traditional medicine, and one of them is using alternative medicine. And the administrator who's deciding which of the two to fund, you can only fund one. They both need $1 million to do their project. The administrator, is a trained scientist. He's an expert, et cetera, et cetera. And in his view, the traditional medicine one will it's 10 times more likely to save lives than the alternative medicine one is. And the reason is that although he doesn't think alternative medicine is, unworthy of any funding, he thinks that it just doesn't usually work as well as traditional medicine does. And when he gets strep throat, he wants penicillin and not, an herbal remedy. And so he says, all right, well, I'm going to give the last $1 million to the traditional medicine one, not the alternative medicine one. I'm doing this because I think it will save more lives. And I think it will save more lives because I think traditional medicine is usually better than alternative medicine. Is that a First Amendment problem?
I don't think so. I think if the administrator believes that traditional medicine is more likely to save lives than alternative ones, and he genuinely believes that. I mean, you have to draw the line.
But that sounds like it's viewpoint. That sounds like you would say it's viewpoint discrimination. I don't understand why that's not viewpoint discrimination, but some of the other hypotheticals you think are viewpoint discrimination.
Because he's not
his viewpoint is alternative medicine is not as good as traditional medicine.
He's not discriminating on the basis of the viewpoint. He's discriminating because he thinks one is much more likely to lead to a successful result than the other. If he was merely saying just because this is alternative, I don't care how well designed it is. I don't care, how valid of a study this is. Just because this one's traditional, I'm funding it, and just because that one's alternative, I'm not. That would be arguably viewpoint discrimination. But I think if he, based on his experience, I mean, at some point, someone has to make a decision about which studies to fund, and we can't fund everything. So, I mean, in an ideal world, we would just study everything and see what works and what doesn't, but we don't live in that world.
Last word from Mr. Chair.
Just an observation. The hypothetical you raised about 10 minutes ago, dealing with what if the government didn't fund anything and it was all done by government agencies? That actually occurred, from about 1880 to about 1930.
How'd that work out?
Not particularly well, but it was the refusal to fund was largely a result of the fact that Southern states weren't getting any of the funding. So the chairman of appropriations happened to be from Alabama, and he just shut off funding. That was that.
I think that our audience has been really treated to getting to listen to Ms. Yanis, getting to listen to Mr. Chero. I've enjoyed hearing from both of you, and again, I'm grateful to have been allowed to be a part of this. I suspect I'm supposed to turn this over either to Professor Destro or to Professor Harmon. Professor Harmon, to conclude.
I'll take it over from here. Thank you, Judge Walker. I agree. I really enjoyed this discussion. I appreciate the subtleties that you brought to this issue. It's been just what we wanted it to be: informative, instructive, and we thank you, Judge Walker. I thank you, Jen and Yanis, and Robert Chero, and our student organizations for another thought-provoking and engaging evening. We will return next year for our 2025 installment of the Seigenthaler Debates here at Catholic University's Columbus School of Law. So on behalf of Professor Robert Destro and myself, A.G. Harmon, I thank you all. Good night.